All right, this one actually led to somewhat of a disagreement here in the office. Somebody who hypothetically,
What? We disagree?
I may have hypothetically been a pantser and a pantsy in high school. Calm down, Bobby. We have Karen and I had very different ideas about this, I think. So you're a paraeducator. During first grade recess, a group of students thinks it's funny to run up behind a peer who's wearing sweatpants and pull them down, exposing the student's underwear. That's our scenario. First question, is the paraeducator a responsible employee? That's going to be the issue. In K-12 schools, reporting student-on-student harassment to any teacher at that school gives the school actual knowledge. I don't think a para is a teacher, so I don't think that's going to be sufficient to do actual knowledge. But for all schools, the test is whether the person who knows and is an official with authority to take corrective action. This is where it would be interesting. A para certainly could tell a kid, go stand against the wall, right? Could a para suspend that kid? No. Could a para send that kid down to the principal? Probably. And so you can see under the new rules, they said this is going to be a case-by-case factual determination as to whether somebody is or is not a responsible employee. You can see how a para cuts both ways. I don't think they would be a responsible employee. I don't think they have enough authority to take the corrective action that they're talking about under Title IX. The safest approach would be to consider them a responsible employee and employ all the strategies that you have. So under state law, I think this cuts against the para. It says administrative and teaching personnel may take certain actions, and then they list those. I think you could give a para the authority to do that, but under state statute, they're not listed there. So that would cut against them being a responsible employee. The second question, is this behavior because of sex? This is really where we disagreed. In my pantsing situation, it truly was. Go back to this, the situation of sweatpants. That's how we determined who got pants. Were they wearing sweatpants? They got pants. That's just how it went. So if you were dumb enough to wear sweatpants, it happened to you. It had nothing to do with your gender. It had nothing to do of sexual arousal or any kind of sexual assault. That was it. And so we do have court cases that say you kind of sort of have to investigate. If the kid says, why'd you do it? He stole my lunch money yesterday. That's not because of sex. That's not on the basis of sex.
Now, just to make it one more step weird, because school lawyers are this way, when Steve says, well, you didn't get pants because you're a boy, you got pants because you're wearing sweatpants. I'm wearing sweatpants because I'm on the spectrum, and I can't stand anything with a buckle or a fastener. Now we've got potential disability-based discrimination. So the don't do that, don't wear sweatpants, it's not gonna fly.
You know it's coming, even if you're on the spectrum. So anyway, I can say that because I'm on the spectrum. All right, age of the students is not determinative. We would likely advise you to investigate as a Title IX issue. That's really the issue. There would, on the one hand, be no downside of being investigating as a Title IX issue. On the other hand, you saw those new regs. Do you seriously want to have to jump through all those hoops? You have to give a written report here, wait 10 days. Give a written report over here, wait 10 days. Have a hearing. Because somebody got pants because they were wearing sweatpants? I don't think so, but again, that's the issue. You can see how we're coming up to those lines. Any questions on that?
You've got the phone, friend.
Let's see. Currently, we don't have a female PE teacher. Do we need to have a female para in the locker room during the changing tides? Somebody's got to be there. Somebody. A body has to be in there. Somebody of some level of responsibility. So yes.